Welcome back to Second to None Media. This is part 2 of our continued coverage of Defendant Conway, aka Yella Beezy's defense response during the evidentiary hearing on the motion in limine in the state of Texas case involving the death of MO3. In this segment, the defense continues presenting its legal arguments and responding to issues raised by the prosecution. This coverage is presented for news reporting, educational purposes, and public interest. All defendants are presumed innocent unless proven guilty in a court of law. Let's continue inside the courtroom.
Yesterday at 3:38, I filed a post-hearing brief and I emailed it to the court. Would you like a paper copy of it?
Yes, please.
May I wrote?
Yes, sir.
May it please the court, Your Honor, we just heard Mr. Yella say that the evidence they seek to admit isn't 404B2 evidence. He said 404B, I assume he means 404B2. But it goes to motive. One of the exceptions to get in evidence not directly related to the crime that the court knows, as an exception to 404B2, is motive. So he said that these aren't extraneous acts or offenses, but every piece of evidence the state wants to present to the court that doesn't go directly to the murder of MO3 is listed in the state's amended note of extraneous evidence dated July the 8th, 2026. So now suddenly the state is pivoting away from this being 404B2 or even 3836 as simply being evidence showing my client's motive. It's important for the court, Your Honor, to distinguish between words and deeds and between ideas and conducts. What the rap music in this case are words and deeds of Mr. Conway. This is what he does for a living. You know, some of it, especially what we heard from DeVarius Moore, aka Trap Boy Freddy, is distasteful in some people's eyes, but still, they do have a First Amendment right to make the music and to publish it. Can't be punished for exercising a constitutional right. And the three-judge panel in the concurring opinion of Hart stated, Your Honor, singing about drugs, guns, and murder is nothing new. It's as prevalent in our culture as singing about God and love. But what these lyrics and music videos have in common is that they are artistic expressions. Using someone's art in the guilt-innocence phase of a trial only as character evidence has the potential of being unfairly prejudicial. That's exactly what the state's trying to do in this case, Your Honor. Now, Hart, another distinction I want to put on Hart, it differs in our case only from our case only in the context of the introduction of the rap videos by the state. Hart was convicted of capital murder, the same offense for which Mr. Conway is charged. In Hart, the defendant testified, and upon the conclusion of his direct testimony, that's the point that the state moved to admit evidence of his rap music. The Court of Criminal Appeals still reversed Hart and granted him a new trial, even though the defendant in Hart took the stand and the rap music that was admitted was as rebuttal evidence. Mr. Conway is not taking the stand in this case. Now, I'm not sure how hard the state's pushing the notion that Mr. Moore, aka Trap Boy Freddy, isn't a co-conspirator. We heard last week Detective Barnes make an analogy with like the CEO of UPS who sent employees out to do things. Mr. Conway is not the CEO of anything. He doesn't control Trap Boy Freddy. He doesn't control any of the individuals involved in this case. What controls whether a person is a co-conspirator is Texas Penal Code 701. That's a co-conspiracy statute that goes directly to the charge or primary offense. What I believe the state's trying to do by trying to introduce all this extraneous evidence is they're trying to peg my client with Pinkerton liability, as I explained in my brief, which is Section 702 party liability. We don't have any Pinkerton liability issues in this case, Your Honor. And I went into great detail about the difference between the two on pages 7 through 9 of my brief. The actual alleged co-conspirators in this case are Jerry Johnson, Keywan White, and Devin Brown. Why? Because they've been indicted. I attached the copies of the indictments in the appendix. Under 801E2E, Texas Rule of Evidence 801E2E, their statements, if it's in furtherance of the conspiracy, could be admitted. But they haven't made any substantive statements in this case, which is why the state's not trying to introduce any of their statements. They're trying to introduce every statement, either public or private, that Trap Boy Freddy's made. But again, Trap Boy Freddy is not a co-conspirator. He's not a co-conspirator under Section 701. They're trying to allude that he's a co-conspirator under Pinkerton liability and Section 702, but there's no evidence of it. They introduced no evidence. Detective Barnes himself stated, he testified under oath, that at this time, there's no probable cause to arrest Trap Boy Freddy. And we keep hearing about a conspiracy and the state's attempt to introduce songs and statements made after MO3's murder. The law is clear, Your Honor, as I point out on pages 11, 12, and 13. The alleged conspiracy in this case ended on November 11, 2020 at about noon when MO3 was murdered. Nothing said or done after that is evidence of the conspiracy unless it's for concealing the alleged crime. Now, does the state allege that anyone involved, whether as an actual or alleged co-conspirator, did anything to conceal? No, the state is alleging the opposite. That they didn't just conceal it, they did the opposite. They sang about it. They went public about it. Those statements cannot be admissible, Your Honor, as I point out, under 801E2E, because the conspiracy, if anyone existed, ended on November 11, 2020 at noon. And further, there's a lot of case law on this that I point out on page 13 of my brief. The statements made by the various individuals in this case through rap music or through Instagram posts or Facebook Live posts, they're not in the furtherance of a conspiracy, Your Honor. They're inadmissible hearsay, and what they are is, there are four types of statements that numerous Texas courts and published opinions have stated are not in furtherance of any conspiracy. Listed on page 13, the first one are casual admissions of culpability to someone the defendant had individually decided to trust, mere narrative descriptions, mere conversations between co-conspirators, and puffing or boast by alleged co-conspirators. Now, this case has a lot of puffing, it has a lot of boasting, but that's all it has. Those statements specifically are not admissible as statements of co-conspirators. Next, Your Honor, we heard Detective Barnes make a comment that MO3's interview with Cam Capone on April 6, 2019, which was a little over 18 months before his death, was as close to a dying declaration as we can get. I asked the court to order the state to instruct Detective Barnes that he cannot say dying declaration. That was not a dying declaration, Your Honor. A dying declaration is controlled by Rule 804B2. And one of the important aspects is that the declarant must have realized that he was at death's door. Now, we don't know exactly, obviously, what was going through MO3's mind. Detective Barnes speculated and said that, well, he, had a general bad feeling that, he might get hurt in some way sometime in the future. But we don't know what else type of conflicts MO3 was into. He was a rapper. He was a provocative rapper. The evidence shows that he manufactured the beef, largely manufactured the beef, with Mr. Conway for commercial purposes. That's, we heard from Dr. Nielsen, that's what these individuals do. They make up beefs, they manufacture them to cause controversy. Why? Because, Your Honor, controversy sells. An uncontroversial, friendly person usually isn't an interesting person. In our society, especially with social media and music, it's the edgy person, the person who says, say crazy things sometimes. That's the person who's interesting. That's the person who draws attention to himself. That's the person that people will pay to listen to. That's what was going on in this case. Now, the state cites several federal cases, Your Honor. I argue that the reliance on those federal cases are misplaced because, number one, those cases are not binding authority, and none of the facts of those cases support the state's contentions. The main three ones that I pointed out in my brief, Your Honor, are Perry, Campbell, and Alvarez. Perry, the relevant page is attached in the appendix, page 8, Your Honor. It's a 55-page opinion. I only attached the first page and the relevant page. And I just want to read from Perry. The general conclusion from courts is that this type of evidence, meaning explicit rap videos and lyrics, are probative and outweigh substantial prejudice when the defendant performs the songs, describes events closely related to the crime, and the evidence is not cumulative.
Your personal information is valuable, and every time you connect online, you're trusting networks to keep your data safe. Whether you're using public Wi-Fi, traveling, working remotely, or just browsing from home, protecting your online privacy matters. NordVPN helps encrypt your internet connection and adds an extra layer of security while you're online. Right now, NordVPN is offering a summer deal with up to 76% off, plus 4 months free, bringing plans down to as low as $3.37 a month with a 30-day money-back guarantee. Protect your digital life today. Check out the offer by scanning the QR code on the screen. Thank you for watching Second to None Media. This concludes Part 2 of the defense's response during the evidentiary hearing. In the next episode, Part 3, we will continue with the final portion of the defense's arguments as attorneys complete their response before the court. If you appreciate our courtroom coverage, please like this video, subscribe to Second to None Media, turn on notifications, and follow us across all platforms for more legal coverage, news, and in-depth reporting. We'll see you in the next courtroom report.